case briefs, and so much more. LSData's got what you're looking for.
The 1965 Supreme Court case Commissioner v. Estate of Noel raised important questions about federal estate tax law. The central issue of the case was whether the proceeds from two flight insurance policies, signed just before the insured's death, should be included in their estate for tax purposes. The policies were taken out on the person's life and named their wife as the beneficiary. The deceased's estate argued that the policies should not be included because the person did not have control over them at the time of their death, and therefore did not possess incidents of ownership. However, the Supreme Court held that the policies were indeed insurance on the life of the decedent, and that the decedent had exercised incidents of ownership in the policies at the time of their death. The Court of Appeals had previously drawn a distinction between life insurance and accident insurance, but the Supreme Court disagreed with their interpretation. Instead, the Supreme Court ruled that flight insurance policies like the ones in question here were considered policies on the life of the decedent and should be included in the estate for federal estate tax purposes. The executors of the estate argued that the decedent's wife owned the policies outright, but the court found that the decedent had the right to assign or change the beneficiary without her consent. The power to do so remained with the decedent at the time of their death, and thus, no transfer of ownership had been made. The judgment of the Court of Appeals was reversed, and the judgment of the tax court was affirmed. The case emphasized that an individual must properly divest themselves of all incidents of ownership over an insurance policy through a valid gift or assignment in order to prevent its inclusion in their gross estate.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.